everything you need to know about products and services that can improve your life. This is Experts on Call on CL 650.
And welcome back. We are talking on our first show of the new year with Adrian Murray, a lawyer with Hammerberg Lawyers. We're talking about rental bylaws, some of the interesting case law that's occurred in this last year, which has an impact on the enforceability of our bylaws, how we apply them, things like time schedules of how we deal with notice for things for people. If you have questions at any point and you'd like a response, we'll be happy to respond on air or send you an email. You can email us at questions@talkaboutstrata.com. And if you'd like more information about rental bylaws and administration and governance of strata corporations, you can go to the Condominium Homeowners Association of British Columbia website at choa.bc.ca. So Adrian, we were talking now, we've gone through and exhausted the whole exemption around owner-developers with respects to the rental disclosure statements. But there's two other kinds of exemptions. So our building adopts a bylaw. Let's just say we prohibit rentals outright. So rentals are prohibited, which the Act allows, but we have three basic exemptions. The first is an exemption where a buyer, whether the first purchaser or a subsequent purchaser after January 1st, 2010, is exempted under the owner-developer's rental disclosure bylaw. But what are the other two kinds of exemptions that people are looking at as well?
The next exemption, and a big one actually, is an exemption for family members. So the owner can always rent to a family member, notwithstanding any rental restriction bylaw. And a family member is defined in the Act as parents, children, or a spouse, spouse's parents, spouse's children. So there's always an ability to rent. Now, the first question people always say, well, what about age restrictions?
Right.
An age restriction will nonetheless apply. So if I've got an age restriction of 55, and a rental prohibition bylaw, although I can rent to my kids, under the rental bylaw, I can't rent to them unless they're 55.
Right.
So the age still trumps a rental bylaw. But leaving that age aside, now I can rent to my family members. I can also rent on the basis of hardship. And the Act contemplates that an owner can apply to the Strata Council for permission to rent if the rental prohibition causes hardship. And the Act doesn't define hardship. We've got some case law around that issue. And what we see from the case law is that the Strata Corporation is entitled to a significant amount of personal information to determine whether there is hardship. Hardship generally translates into some sort of financial hardship, usually accompanied by something else. For example, I own a strata lot, and I've been forced to go to New Brunswick to go to university for 3 years. I don't want to sell my strata lot. I want to return back to Vancouver when I'm finished, but I can't afford to maintain a residence in New Brunswick and a residence in Vancouver. If I can establish that, and I can establish that it's unaffordable, I've got a clear limited period of time where I will be away and my intention to return, then that may qualify as hardship. In fact, in my view, it would. And the Strata Corporation is then obligated to permit me to rent. The Strata Corporation can put a time limit on the rental.
Right.
So they may say 1 year.
Right.
Come back at the end of 1 year and let's assess your financial circumstances at that point in time. They can also require me to rent within a certain period of time. And so they can put conditions on the rental.
But can they, as a condition of this, say, we'll agree to your hardship rental, but we want to be able to interview the tenant before the tenant comes in?
Well, that's another prohibition under the Strata Property Act. And the Act very clearly says that a strata corporation must not screen tenants, establish any screening criteria, require the approval of tenants. I've had strata corporations ask me if they can get criminal record checks on tenants. They want credit checks. Not possible.
Right.
So the Act is clear that the matter between the landlord and the tenant, the owner and the tenant, is between those two, and the Strata Corporation cannot interfere with that process. So they can put restrictions on the hardship, but they can't interfere with the process of finding the tenant. Now, coming back to hardship, the Strata Property Act has some very specific time frames that the strata corporation must meet in respect of responding to a request for hardship and responding to a request for a hearing and replying after the hearing. We've had an interesting case come up just late fall where an owner had applied for hardship. The strata corporation denied it. The strata corporation was then fining the owner, and they were into I don't know, $15,000-$16,000 in fines. The owner then applied to court to have, or the strata corporation applied to court to have a to obtain a judgment for the fines. What the owner argued in that case was that the strata corporation had not advised him that they had refused his hardship application within the time required by the Act. And without going into a lot of the timing details, what the conclusion was is that the Strata Council was a day late in advising the owner in writing that his hardship application had been denied. They had told him verbally, but they hadn't put it in writing, and the Act requires it in writing within 7 days, and as a consequence, they'd given him notice on the 8th day, and the court said, sorry, you're out of time. Now, the other thing about hardship is if the strata corporation doesn't meet the hardship deadlines, the exemption is automatically allowed. So as an owner, if I've applied and the strata hasn't responded to me, or hasn't held the hearing, or hasn't given me the decision in time, my hardship application proceeds and I am able to rent. End of story. So in this case, the court said, well, strata, you're a day late, you're out of time. I'm not upholding the fines because this owner was permitted to rent based on hardship.
So for every property manager and every strata council president and strata council member out there who think that the bylaws and the Act are just guidelines, it's a little bit of a wake-up call for them.
Absolutely. This was, I think, a decision that stunned not only the strata council, but pretty much everyone who's read it. And in fact, I can't disagree with the judge because the Act is very clear. The Act mandates deadlines.
Yeah.
And the court very clearly in this case told us, pay attention, strata managers and strata councils.
So right now, though, one of the challenges is I make an application as an owner for a hardship exemption. I've lost my job. I'm going to have to live with my parents for a couple months till I can get my job back. My poor parents. We're going to deal with how I can pay my mortgage. I go to my strata council, make a hardship application. They meet all the guidelines, but they say, you know what, you look like you can manage. We're going to deny the hardship application. At this point in history, if I want to dispute something, I'm going to Supreme Court, which is going to be fairly costly as an owner. And if I'm a person in hardship already, I probably don't have the resources to go to court to be able to dispute this.
Well, absolutely true. I mean, that's the horrible sort of contradiction of all of this is that
Right.
if you have been unreasonably denied, or in your view, unreasonably denied, your access to recourse is very, very limited. Of course, we know that's going to change very soon with the coming of the Civil Resolution Tribunal.
With Civil Resolution Tribunal, as an individual owner, hopefully by the end of this year, when I get denied my hardship, I will be able to get into a dispute resolution process where someone else is going to scrutinize the decision-making process of the Strata Council, and it's not going to be that costly.
Well, and that's right, and I think that's actually going to take us in a slightly different direction, because I know that there are councils right now that make a decision that is partly based on the fact that they know that the owner can't challenge it.
Right.
And so strata councils in the near future have the potential to be under significantly more scrutiny. And I think that's going to improve the overall decision-making and processes that strata councils use. The cases that do go to court are clearly in support of that we need the processes. As I've indicated, that the December case in Carnahan talked about the process that we need, that required by the Act. The case of Strozik talks about the deadlines, and although they're both contained, both provisions of the Act, what the courts are saying is pay attention. These are obligatory requirements for strata corporations.
And the bylaws do matter. The bylaws are enforceable. They've been upheld by the courts. If as an owner you think you're going to just challenge the process, it's going to get costly for you. The other side of this, though, we have, we're a strata council. We limit rentals to 5 units, and we have an owner who's just decided he's going to totally disregard it. What are the penalties?
Well, it's a bylaw. A bylaw then can be enforced. Now, a couple of things happen here. Section 135 of the Strata Property Act sets out, again, a process that must be followed to enforce a bylaw. And that very simply is the complaint must be received by the Strata Council. The owner must be notified in writing of the particulars of the complaint and provided with an opportunity to respond, which means that I can't just write you a letter saying you're renting your unit, you're in violation of the bylaw, we fine you. Right. So I have to give you an opportunity to respond. But then the Strata Property Act, in recognizing, I think, the importance of rental bylaws, has increased the penalty for fines. Standard bylaws, the maximum penalty is $200 every 7 days if it's a continuing offense. For a rental bylaw, the maximum penalty is $500 every 7 days. So the legislators really understood that they needed to provide a disincentive to investors to say, if I'm going to ignore a rental restriction bylaw, I'm certainly going to do it at my financial peril. Now, we had a case about a year and a half ago that upheld, year and a half, maybe a little longer, upheld penalties of in excess of $18,000 in fines. So the fines are significant, and the courts will uphold them if the bylaw is enforceable and has been enforced according to Section 135 of the Act. So process in terms of the Strata Council is follow the bylaw enforcement process, levy fines if appropriate, and at some point, if it appears that fines are not going to change the behavior of the owner, then at that point seek legal advice, and you can either really do one of two things. You can go to small claims court to get a judgment for the fines, but that's all you're going to get, or you can go to Supreme Court, get a judgment for the fines, and get an order that the owner comply with the bylaws. And that's likely, in something that severe, that's likely what you're going to want to do.
So again, it starts out being a little costly for a strata corporation, and whether they recover it or are successful or not relies on a lot of variables: how they enforce the bylaw, whether the bylaw was enforceable, did they follow the procedures of the Act, time periods, a number of questionable things. But there again is something that will probably transition as we go through the tribunal with respects to enforcement of bylaws and bylaw application and getting owners to comply with bylaws.
Well, and again, I think that just the existence of the tribunal will be perhaps enough in many cases to encourage owners to comply, because they know now that a strata corporation that may have been reluctant to go to Supreme Court and spend the money for that process can very easily use the tribunal process. So it hopefully will change just the general dynamic of conduct within stratas at both angles. Right. Strata councils knowing that they're going to be scrutinized and by a body that isn't as difficult to approach as a Supreme Court. Right. And owners who know that strata corporations can take advantage of it.
No, exactly. I'm Tony Giaventu, the host of QuayPacific's Talk About Strata, in studio with Adrian Murray, a lawyer from Hammerberg Lawyers, and we'll be right back after these messages.
This is Experts on Call on CIL 650.